Hi all, thanks for joining our Corporate Governance and Cybersecurity program, which is part of our continuing series of webinars on dealing with issues raised by the global COVID-19 pandemic. My name is Ron Feynman, and my colleagues joining me are Todd Lenson, a fellow corporate partner and co-chair of the Equity Capital Markets and Public Companies Group, and Sam Atari, who is from our litigation department and a leader of our cybersecurity group, in which I also participate. We have spent hundreds of hours in the boardroom representing corporate boards, independent directors, and special committees, in my case, mostly for investment company clients. We're going to try to leave time for questions at the end. Submit them using the button on your screen, and we'll try to answer at the end or try to respond individually, or reach out to any of us afterwards. Just a quick review. Board responsibilities are enunciated in a case that lawyers call Caremark, referred to as Caremark Duties. Caremark Duties arise from a case called Caremark International, which was derivative litigation brought by shareholders against the board. And the Delaware Chancery Court found that in some cases, the failure to establish an information and reporting system could render directors liable for a breach of the duty of loyalty, and good faith, which is a component of the duty of loyalty. However, that case expressed the difficulty of succeeding on such a claim, and that establishing lack of good faith is a necessary condition to liability. Perhaps you've heard the one about the ice cream company, where the ice cream manufacturing at Bluebell Creameries was tainted by an outbreak of listeria that infected the products sent out to stores. Ultimately, 3 people died as a result. And Chief Judge Strine for the Delaware Supreme Court found that it was cognizable that the Bluebell board failed to implement any monitoring system for what was their single product, over which they should have been exercising proper oversight, and essentially their minutes and their board book submissions did not demonstrate that the board had paid attention to health and safety concerns, despite the fact that they argued that as a matter that they always took under advisement operational circumstances, but there was nothing specific about the risk that the product would be bad, and the possible outcome which arose, that the products were all recalled, production had to be halted, the company's finances failed sufficiently that a private equity sponsor had to be brought in, diluting the public shareholders. So while this case shows that liability is possible, it also provides some lessons as to what can be done in order to avoid the risks that are represented by the case. So first, if your board has not met since the beginning of the COVID-19 crisis, a meeting should be calendared right away, and possibly a schedule for follow-up meetings as periodically as the crisis continues until conditions have come back to normal. There should be specific reference in the agendas to the oversight of risks from the situation, and there should be assignment of responsibilities to oversee specific areas of risk to the appropriate committees, or a new committee can be formed to, an ad hoc committee can be formed to address the crisis. The board should make sure that it is having government inquiries brought to its attention. If there is testing going on to demonstrate the level of risk, or stress testing, it should be brought to the board's attention. A follow-up process for these issues should be brought to the fore, and the records should show that questions raised were appropriately followed up. Make sure, obviously, that minutes show that attention was paid to the relevant agenda items. Moving to more specific issues, Todd, why don't you take it?
Sure. Thank you, Ron. This is Todd Lenson, and as Ron said, I co-chair the firm's capital markets and public companies practice and represent public companies, private equity funds, and their portfolio companies on all aspects of their transactional business, but in particular, regularly advise boards of directors of public companies on governance and board-related matters. So together with Ron and Samantha, we're going to take you through a very high level of the key areas of focus for the board in responding to coronavirus, as well as the economic shutdown and general economic conditions. So we're going to start with the business. The first item is business and stakeholder risk. So the board needs to review and receive timely updates on the material risk to the business and its stakeholders. And these should be the risks that arise directly from the pandemic, as well as from the ongoing economic shutdown and market conditions. First and foremost, the board should be working with management to ensure the health and safety of its employees, other stakeholders, and the general public. Second, the board should continually review and work with management to mitigate, identify and mitigate the key business risks facing the company and its stakeholders. The stakeholders include the shareholders, the employees, customers, suppliers, and other key third parties, creditors, the governmental agencies and regulatory agencies, if applicable, unions, and the surrounding communities from which the company draws resources. And the company should be, the board should be focused on short-term, mid-term, and long-term. And this is going to differ by company, by industry, and by the challenges that each company faces as a result of COVID-19. These areas of focus should include, for example, the things we're seeing: business continuity. For some companies, it's survival. For some companies, it's how to grow and challenge, how to grow, or work strategically under these times, and everything in between. Succession planning, I think, is very key, and particularly temporary succession planning. What happens if one or more of your critical members of management or others were to become incapacitated or sick because of the virus? And I think that stress testing those are important. Incident and crisis management. What happens if there's an outbreak at one of your facilities? Things like that. And then customer and supply chain, because we are, all companies are truly dependent on third parties here. And even if your company is quote unquote healthy or able to function, whether it's remotely or through other things, your customers and suppliers may not be able to. I'm going to give an example here on temporary succession planning, which, for example, the Altria Group 2 weeks ago came out and said that its finance chief will fill in for their chairman and CEO who contacted coronavirus until this chairman and CEO has returned from his leave. So I think that that's just an example of something out there. So I think the second critical area for companies to focus on are their liquidity and financial risk. And here, the directors should be receiving timely updates on the company's short-term liquidity needs, liquidity resources, and financial obligations. These obviously include the company's debt. I think that goes without saying. When is principal payments due? When are interest payments due? What lines of credit are available? Can they draw on their revolver? What type of incremental debt capacity does the company have under its debt documents, and what type of maintenance, for example, covenants, key covenant terms, including maintenance, key person, all of that should be done. I think that's clear. I think the second thing which is of critical importance is looking at your other contractual obligations and commitments. And within these, there could be significant financial obligations which either are due or coming up, or could be triggered or springing in here. So things like leases, I think everybody's paying attention to. Commercial agreements where there's minimum commitments, milestone payments, take or pay, areas where companies, might need to post collateral, where they posted LCs, looking at your employment agreements, your employee benefit plans, your union contracts, again, looking at off-balance sheet arrangements, all things which are, I think, part and parcel of a annual report on 10K, and this should be looked at. I think as part of this, also, companies should be, and I think they are, looking at their liquidity and their uses of capital, their dividend policy, both common dividends, which are typically discretionary, preferred stock dividends, which might be mandatory, and share repurchases, which we're going to come back to. And again, I just point out this list is illustrative. Every company is going to be different, and it's going to be very specific industry by industry and company by company, but I think these are the things to focus on. I think the third area of critical importance is regulatory requirements, licensing, and permits. And here, companies need to be focusing on the legal and regulatory developments across all jurisdictions. That's domestic, federal, state, local, foreign for many companies, and state, local, provincial, and foreign jurisdictions. This could be in and of itself a monumental task given how various countries are responding here. And I think one of the critical things which we will point out here that we've seen is maintain open lines of dialogue and communication with regulators. Regulators need to be and should be the company's friend, and the board should be ensuring that management is focusing on all of these types of things and should be receiving at the periodic meetings that Ron referred to earlier, a report on all this. Again, this is going to differ by companies. It's going to be more critical in highly regulated companies, obviously less critical in companies that are subject to regulation. So with that, I'm going to turn it over to my colleague Samantha Atari, who's going to talk about cybersecurity and related matters in the context of coronavirus.
Thanks, Todd. This is a good segue talking about regulators. As many of you are aware, I'm sure, the SEC has repeatedly flagged their expectation of board involvement in cybersecurity issues. And as recent as earlier this year, they put out some guidance based on reviews that they have done over the past few years and examinations that are best practices, many of which have really become kind of industry standard. But one area that they spent some time on flagging was, again, board involvement in cybersecurity issues, and an expectation that the board is being briefed by the CISO, Chief Information Security Officer, or CIO, Chief Information Officer, that the board is engaged in cyber issues, involved, has an understanding of contingency plans. We talked a little bit earlier about incident response around medical issues like COVID, but there are also obviously incident response plans that organizations should have in place to deal with cyber emergencies. And in particular, I wanted to flag issues to discuss with your information, whether it's your CISO or CIO or other technologists that are reporting to the board, things to discuss with them to make sure the company is prepared, training, and addressing. So here you'll see on the screen are some trending scams that are COVID related. The FTC was one of the first regulators to put out guidance on COVID-19 related cybersecurity scams, but quickly other regulators have come out with their own alerts flagging these issues, from DOJ to state AG's offices. What is being seen is an uptick in phishing scams, corrupted attachments, attempts to gain access into, behind firewalls and into company systems, and an uptick in man-in-the-middle abuses. So on the phishing scams, corrupted attachments, what is being seen is COVID related. So emails coming into companies purporting to provide health information from the CDC or the WHO, even more specific kind of spear phishing that look to be from healthcare providers or local, state, DOH. These are often soliciting personal information of potentially of your employees, but they're also a way into the company. Corrupted links or files can have malware. So the FTC and other organizations are encouraging companies to be proactive both in training employees on how to recognize these phishing scams, these corrupted information, but also they are encouraging proactive sharing of real information. So making sure that your employees are getting links, have portals with links and information to the real sources of information on COVID-19, whether it's sources of information internally at the organization or providing links to the official departments of health, World Health Organization, et cetera, as one way to sort of minimize the temptation to link onto those fraudulent emails, et cetera, if employees know where to go. So it's more important than ever to have good cyber hygiene because so many organizations are now more disparate with employees working remotely. So to the extent that you haven't recently done this, it's encouraged to be training employees on how to identify and combat these phishing emails. They're also coming as spam. Look at your vendor policies and protocols. Make sure that no one is attempting to put in place vendor arrangements that are not following the policies and protocols you have in place, because with everyone working remotely, this is an ideal time for man-in-the-middle, which I'll talk about in a moment. Also encouraging your employees secure strong passwords on devices. Many people are working from home. Do they have secure, strong passwords on their home routers and other gateways to the internet? So I mentioned man-in-the-middle. So for those of you who aren't familiar, man-in-the-middle is a common way of a fraudster inserting themselves in the middle of a transaction They often take the form of someone inserting themselves and requesting payment on some kind of vendor contract or an invoice, and they will provide new routing or wire instructions, and the two parties, the innocent parties, have no idea that there's someone in the middle now redirecting funds elsewhere. The reason why there's such an uptick in man in the middle right now, and in fact we've seen some regulators putting out strong cautionary guidance on this, is because they're much more effective when people are not near each other, right? If a new wiring instruction comes in to reroute tens of thousands or millions of dollars to a new wire account, if your CFO is sitting next door to your procurement head, it's easy enough for them to pop over or pick up the phone and say, what is this? Have you confirmed that these are the appropriate wire instructions? Why are we getting new instructions? When people are remote, much less likely to do that, much easier to insert. There's a sense of urgency right now, just generally around the pandemic, and that sense of time sensitivity and urgency is also a tool of man in the middle. So this is an excellent time to make sure that your company is rolling out some guidance on man in the middle, is really enforcing vendor policies, and encouraging people to pick up the phone, to not be changing wire instructions without some real concrete confirmations. Another thing to be focused on at your companies with people working remotely is we are all surrounded by listening devices. We've got Alexas, Google Dots, Nest Cams running. Many people have decamped from cities to vacation homes or remote locations where you might not even recall that you've got a Nest Cam sitting in the living room to monitor the property, and now you're taking confidential calls, and that may likely be recorded by a third party and sitting up there for days or weeks or months. These third parties are obviously all vulnerable to breaches and hacking, and so be cautious to turn off those devices, encourage employees working remotely to not be having confidential work calls around those devices. And again, it's just a good time to encourage strong remote working, good cyber hygiene, and even paper hygiene, not leaving out confidential paperwork, screens accessible to roommates, etc. We've all seen Zoom and other telecommunication tools are coming under increased scrutiny. If you're using them at the organization, press your tech people to make sure you're using the most heightened security settings on confidential calls. And also be careful with geolocation data. If you're collecting it on your employees, make sure you're disclosing that. There's a lot of regulation around the use of geolocation. So suddenly with your workforce remote, just be careful that you're abiding by those regulations. And just lastly, please know that regulators are, while they're somewhat sensitive to these issues, GDPR, EU regulators have been issuing statements that they understand that resources are being diverted away from privacy initiatives and efforts to deal with the COVID-19 crisis, but they are still out there regulating. The California Consumer Privacy Act, which went into effect on January 1st, the California AG so far has said that there will be no delays on enforcement, which is commencing in July, and they are still putting out tweaks to the regulations and periodically accepting commentary. So to the extent that you are working on a CCPA compliant program, that really unfortunately cannot stall in any way, because this regulator as of now says they will be enforcing in the next few months. And if you collect any New York data, New York Privacy Shield Act went into effect in March. There are robust requirements for cyber programs, leadership requirements, training, third-party and vendor service requirements. Those are all in effect right now, not suspended in any way because of COVID, as far as we know, and they're being regulated, and there are expanded definitions of breach, reporting requirements, and what information is protected. So in this environment, it is important to know when you've been breached under these statutes and when you have to report. So I'll turn this back over to Todd and Ron.
So one issue that boards have been highly concerned with is D&O insurance and whether they're going to be covered in the event that litigation arises. Board should ask the company's insurance broker or the legal teams with which they interact on these matters to review the existing D&O insurance policies. They should assess the litigation risk as it develops. Several suits have already been brought as a result of COVID, although they're not relevant to most companies. And assure that somebody keeps informed about claims that are being made and compares them with the policy provisions on which the board intends to rely. Also, perhaps how members of the Tower of Insurance are responding. Consider whether there are enhancements that can be purchased, additional Side A coverage. My understanding from several board conversations is that policies are rather expensive these days and may, I'm not sure I'd call it price gouging, but insurance is a cyclical industry in terms of pricing. So if there's a financial restructuring that's required, then obviously consider tail coverage and appropriate replacement. Todd?
Great. So the next, we're going to talk, go through a handful of topics here fairly quickly, given timing, and we know there's been a lot written about this, but we did want to hit some highlights. So I think first is proxy. We're in proxy season. Lots of companies, proxy materials are out or in the process of being sent out, and there's been a lot of questions about postponement, adjournment, and more common, moving to a virtual meeting. And these are all questions of state law and the company's organizational documents, but these are all questions that board should be thinking about, asking management about, and we are seeing
and their lawyers, because what we've learned is that as a matter of state law, there's a difference between Delaware and certain other states. We have determined under Delaware law it's allowable, if necessary, if a meeting's been called, to host the meeting outside a closed space, such as a hotel venue. But the permissibility of virtual meetings depends on a thorough review of the organizational documents as well as state law. And under certain corporation statutes, there is a provision for postponements before the meeting is actually held, but other state statutes are vague on the subject.
So I think next we're going to talk about disclosure practices and recent SEC guidance. And here, board should be reviewing the disclosure process with management, including their prior earnings guidance. Board should be focusing on the disclosure of material risks and material changes to the business as a result of COVID-19. I'm going to quote the SEC Chairman Clayton, who recently encouraged continual disclosures amid the pandemic. And he said specifically, the SEC is focused on ensuring companies provide material information to investors, including information relating to current and expected effects of COVID-19 as promptly as practicable. Earnings guidance is something boards should be paying attention to and working with management regarding whether to update or pull back on prior earnings guidance. And here, the rules haven't changed at all, and those are the companies under no obligation generally to update their guidance unless they are currently in the market for a securities offering, engaging in repurchases or other transactions. and here's the or, speaking to the market. And here's where, again, boards should be consulting with management and counsel. Many companies have chosen to update their disclosure on earnings guidance given the magnitude of the pandemic. The SEC extended filing deadlines for companies who can't make it. They are very focused on risk factors, MD&A, and guidance, as we talked about. And I want to say again, as we're in proxy season, do not lose focus on shareholder engagement, and in particular, the impact of ESG. We're going to see proxy advisory firms come out with their recommendations. The large institutional investors like BlackRock have come out in the past couple of weeks with statements. Companies are going to face potential negative investor votes unrelated to COVID-19 and potential activism, which we're going to come back to. Next, I want to talk a little bit about stock and debt repurchases and trading by insiders. We're getting a lot of calls on this topic. A lot of companies are focused on this, both their ability, if they have the capital and liquidity, to repurchase equity and or debt. And we've gotten lots of calls about insiders buying given depressed stock prices. So here again, everyone's got to pay attention to MNPI, make sure there's not material non-public information. Boards should be asking about their insider trading policies and blackout periods. Consideration should be given about most companies today are in quarterly blackout periods, just given where we are in April, but having event-specific blackout periods. And I think it's a really good time to focus and revisit the benefits of 10b5-1 plans. With that, I'm going to turn it over to Ron, who's going to talk about exec comp.
All I think that needs to be said about executive compensation is that compensation committees are going to be faced with novel requests for changes as a result of the fact that revenues and income will be insufficient to hit bonus targets for chief executives. Underlying officers will also be facing challenges to bonuses, and obviously lower level workers and wage earners are also going to be in need for adjustments to their compensation. All this is going to come before the board, and the board should take account of public relations considerations that are going to affect how the company is viewed in the marketplace.
So I think the next topic I want to talk a little bit about is communications with stockholders, employees, and other stakeholders. And I think here the board should be reviewing the communication plans that are generally in effect with management. I think it's critically important for companies at this time to identify who the authorized spokesperson or persons are. Inquiries should be directed to those persons. Presumably that's the CEO, the chairman, or the lead independent director, if the chairman and CEO are the same. And these are communications really with all stakeholders. So clearly stockholders, communication to the market, employee communications are critical, and communication to other stakeholders. Again, those are third parties, and in particular regulators. The last thing I want to say in this is I will remind you, if you want to go back one, is Reg FD continues to apply. And in late March, the co-directors of the SEC Division of Enforcement put out a statement, a very unusual statement, reminding market participants of the critical importance of maintaining proper control over the dissemination of MNPI, and reminding them of Reg FD, and stating that they are stressing the need to comply with Reg FD. So I would not be surprised if we see enforcement actions coming down the road, given the statement here. So again, make sure your management is reviewing and adhering to Reg FD policy. And then the last that I want to talk a couple of minutes about is M&A. Here, companies are on both sides here. The board should be receiving strategic updates from management, focusing on both vulnerabilities and, if applicable, opportunities. On vulnerabilities, we are seeing an uptick of shareholder activism. It is critical that boards review their shareholder activism and hostile takeover action plans and defenses. Along these lines, with depressed stock prices, companies could become more the target for activist shareholders and accumulators of stock. And we are seeing some companies put shareholder rights plans or poison pills on the shelf, as they say. Again, I don't think anything has changed here in terms of the current status of how these plans are viewed by the institutional investor community, but boards should be asking the questions today and at least thinking about it. And then the last thing I want to talk about for some companies are, now's the time to review strategic opportunities. Whether or not one can execute on them today is probably a question, but to the extent that companies are healthy, doing well, financially stable, there will be opportunities that come out of this, and hopefully more in the shorter term, short to midterm, than in the long term. And companies should be prepared to take advantage of those opportunities. And we recognize that management teams and boards are very focused on the current effect of COVID-19, but there are things which boards can be doing, subcommittees of directors or others, together with management, to start to evaluate what the world is going to look like, if and when this comes to an end, and how best to position the company for long-term success and build shareholder and other stakeholder value. So with that, we're going to open it up for any Q&A. I think there's a button on the bottom of the screen where you can type in any questions. And also, please feel free to reach out to Ron, Samantha, or myself offline if anyone wants to talk about any topics or wants more detail. In the absence of any questions, well, we thank everyone for their time, and hope everybody found this helpful. We wish everybody health and safety. Thank you.